Before you spend money on a notary class, bond, stamp, or signing agent package, check this first. A felony record may block you in some states. The quick answer is yes. A felon can become a notary in some states, but not in every state and not automatically. This matters because you do not want to pay first, then find out the state was never going to approve you. This is not legal advice. Check your own state's Secretary of State, Governor's Office, or Notary Commissioning Office. And near the end, we'll cover the mistake that can get people rejected fast. Even when their record might not have ended the process, notary rules are state rules. There is no single federal rule saying every person with a felony can become a notary or every person with a felony cannot become one. Eligibility depends on the commissioning authority in that state. Notary eligibility is handled at the state level. So don't assume you are banned everywhere, but also don't assume you qualify. States may look at what the felony was, how long ago your sentence ended, and whether the conviction involved fraud, theft, forgery, dishonesty, identity crimes, or false statements. They may also ask whether your civil rights were restored or whether you received a pardon, expungement, set aside, or certificate of restoration. So the real question is not just, do you have a felony? The real question is, what does your state say about your record? A notary is trusted with identity, signatures, oaths, and important documents. Pennsylvania describes notaries as public officers who perform official acts like witnessing signatures and administering oaths. Notaries help verify important transactions. That is why criminal history matters. It does not mean you are a bad person forever. It means the state is asking a public trust question. The first outcome is a strong disqualification. New York says that generally a person convicted of a felony cannot be appointed as a notary public. New York treats felony convictions as a major barrier. Texas is also strict. Texas rules say a person is not eligible if they have a final conviction for a felony or a crime involving moral turpitude. But there are exceptions if the conviction was set aside or if the person received a pardon or certificate restoring citizenship rights. Texas notary eligibility has specific criminal history limits. The second outcome is a waiting period. Michigan says a person convicted of a felony is disqualified for at least 10 years after completing the sentence, including imprisonment, parole, probation, and payment of fines, costs, and assessments. Michigan has a 10-year post-sentence disqualification period. The third outcome is a case-by-case review. Florida allows people with a felony conviction, withheld adjudication, or probation history to submit extra documents, including restoration of civil rights or pardon paperwork when it applies. Florida allows additional documentation for applicants with criminal history. Pennsylvania says a felony or an offense involving fraud, dishonesty, or deceit can create a presumption of ineligibility. But that presumption may be rebutted in extraordinary circumstances with clear and convincing evidence of full rehabilitation. Pennsylvania allows a limited rehabilitation path. So, one state may say no, another may say wait, another may say show us the documents. Do not start by buying supplies. Start by finding your state's official notary office website. Read the criminal history rules carefully. Then look at the exact application question before answering anything. Next, gather your records. That may include court records, sentencing records, probation or parole completion papers, and proof that fines or costs were paid. Then check your legal status. Were your civil rights restored? Do you have a pardon? Was the conviction expunged, sealed, set aside, or handled through some other legal relief? Do not guess. If the rule is unclear, contact the state notary office before paying for a course, bond, stamp, supplies, or signing agent package. A training company may sell you a class. That does not mean the state will approve your commission. Also, becoming a notary is not the same as becoming a notary signing agent. Signing agent work may require private background checks from lenders, title companies, or signing platforms. Now, here's the mistake I mentioned earlier. Do not hide the conviction because it is old, sealed, embarrassing, or complicated. False answers can create a bigger problem than the original record. If the application asks for disclosure, answer honestly and follow the instructions. The safer order is simple. Check eligibility first. Gather documents second. Spend money last. If your state says no right now, that does not mean every door is closed. You may still be able to build experience in office support, records, courier work, scanning, mailroom work, reception, intake, or document preparation support where allowed. The point is not to guess. The point is to work from facts. So, can a felon become a notary? Yes, in some states. No, it is not guaranteed. The answer depends on your state, your conviction, how much time has passed, whether your rights were restored, whether you received legal relief, and whether the notary office believes you meet its character rules. Before you spend money, check the official state notary office. Be honest on the application. Gather your documents before applying. If this helped, like this video, subscribe to Fresh Start Society, and visit freshstartsocietyhq.com for more information.